Hey, good afternoon. Carl Rominger here, 540-0580. Legal Talk line. Call in with your legal questions. We'll answer them here on the air. What can I tell you? I was in a jury trial the last 2 days. The jury went out yesterday afternoon at 4 o'clock, kept me in the Chambersburg courthouse at 7:30 just to come back with a guilty. Very angry at them. The answer is they did their job, I guess. Based on the facts of the case, I'm surprised they actually rendered a conviction. But here's the dealio. There's a fight, and two young guys fight two older guys, and the big question is who started the fight, because if the young guys started the fight, then it's a crime. If the young guys are defending themselves, then it's self-defense. And I think the jury couldn't wrap their mind around the fact that the guys who started the fight were the ones who got the beat down, so to speak, and had all the injuries. And so for some reason out there, people tend to think that the aggressor is the one who isn't injured, and the one who's injured is the victim. And interestingly, police officers seem to know that. And so when they make their initial charging decisions, they will often look at the case and go, okay, I got four guys. Everybody claims the other guy started the fight, so I'll just charge the guy left standing as the perpetrator and the guy with the big black eye and the broken nose as the victim, because if you're a 78-year-old female on a jury, that seems to be the way you resolve those questions. Anyhow, I'm a little bitter. Anyhow, can't you tell? 540-0580. Dave, you're on the air.
Hey, how's it going? Quick question for you. I'm a songwriter and singer, and I was just kind of wondering the best way to handle the rights to songs, because obviously it's not just CD sales anymore and things like that. But
yeah, it's been a while. I did some work for an online radio station a number of years back, and so we ended up doing some rights issues only because they had to pay royalties on all the songs they played, and there's a whole system through the Library of Congress. What I would tell you is, obviously, you need to copyright the lyrics and the music. If you're writing the song, there's a writing credit. There's also a credit for the artist, and there's also credit for the production value as well. And traditional media, if I remember this right, like terrestrial radio only pays on two of those, which is, I believe, the do you know, Shane, which two royalties they pay on terrestrial radio versus online, or no? Okay. But anyhow, if you play online or in other new medias, then there's additional royalties as well. So anywho, all I would tell you is I know you got to copyright it, and beyond that, I would start at the Library of Congress, because they're actually the ones who manage all that, and they have a lot of good self-help material on their website.
Okay, go ahead.
Yeah, I'm just saying that would be a good place to start, but I'm not sure how else to help you generally here.
All right. I guess basically maybe I should sort of shift the question. Because things are not just purchase of records in general anymore, they're more like people are downloading one and two songs from an artist.
Right.
And, occasionally these people are buying the entire album, but if a song that I had written would come up onto somebody else's album, the album sales are a certain revenue, and then obviously the single downloads would be a separate
separate revenue stream, absolutely. And I can tell you, I'll give you an example. Radio stations have to send in their playlist, and then they have to send in royalty money, and then the Library of Congress, the Librarian of Congress, I should say, divvies it out on a formula, for instance. So there's different ways that's done.
Okay. And then
go ahead.
Second question, this is completely off subject, but we had a carpet cleaning done, and it was during the last couple weeks here, and it was in a non-flooded area. It was just a cleaning. It wasn't a restoration or anything like that.
Okay.
They came in, basically cleaned the carpets. We let them dry, or let the allotted dry time go by, and there was a stench that came out of these carpets that was of mildew and mold. It smelled like a moldy basement. It smelled like their water had cross-contaminated somehow into using what water that they were using in somebody else's possible cleanup or restoration project.
Gotcha.
It smelled like pet and this, that, and the other thing. And they kept calling back, when we had to spray an enzyme on it, and then we wait for another day, this, that, and the other thing. Well, we were concerned about the actual condition of what was happening underneath the carpets. We had to open up the windows for air circulation, but because of the moisture in the air, we weren't really getting any, dry air in there to dry the actual carpets. So 4 days goes by, and the carpets were pretty much, starting to dry out, but you can still smell that must.
Right.
In the future of the life of that carpet, because it was only like a year old, it's fairly new renovation project that was just done. We're just kind of upkeeping the carpet, not necessarily cleaning it. Mold might start to brew and kind of, I guess, sort of fester in that stuff. And who, other than the carpet company, and after they say, well, we'll come out and re-clean it for you. What do you do in that situation? I mean, here we are sitting on $4,000 worth of carpet that smells like a moldy basement.
Right. Well, you may have a lawsuit against the cleaner for damaging your carpet, and that may include the replacement. I'd have to see whatever contract you signed with them, if anything. But assuming you didn't sign a contract, you'd at least have a claim for those damages. How do you prove it, though? Of course, they're going to did they admit they cross-contaminated, or are they going to say, oh, no, we must have just brought out what was already in your carpet?
They're basically saying, and this is where I was starting to think to myself, well, should I get, like, somebody with an extractor, take whatever moisture's in there to a lab somewhere and see if there is pet and, cat and dog or whatever, dander or whatever in there. I don't know if they can test for that.
Right.
Or mold or mildew or whatever. And these are things going through my mind because I watch way too much CSI and crap like that. But, you know what I mean? I'm like, oh, run it down to the lab. But anyway, I didn't know what the steps were to do. And then, of course, they want to come out, oh, we'll re-clean it and this, that, and the other thing. I'm like, well, that's sort of adding insult to injury. And then I asked about how the system works, and they explained to me there's no possible way cross-contamination.
Right.
I'm like, well, how do they, empty out?
I would check with another carpet guy, okay?
Right.
And see what they say about possibility of cross-contamination, et cetera. Because if it is impossible, then it is impossible. I don't know. I don't know the answer to that. If it isn't impossible, you can find out how it could be done. And then you might want to just have the second guy come in and say what he needs to do or whether he thinks they actually caused it or not. And then he can go back to the first guy. Of course, you could always let the first guy come and try and make it right. And in fact, if you sue him later, he's going to say, hey, I offered to make it right and you didn't let me come in and fix it.
Right.
So the cheapest one would be just to have them come back in and re-clean it. And obviously you're hoping they're going to try to do a really good job since they know you're already upset.
All right.
All right, man. Those are just some thoughts.
Yeah, thanks, Steve.
All right, take care, brother. 540-0580. I'll see you after the break. Hey, welcome back. Carl Rominger here answering your legal questions live on WHP 580. And, of course, we'll be going all the way through till 3 o'clock. So if you're driving around, you just can't quite get to a phone or something, just give us a buzz here when you do, 540-0580. Andrew, did you have a suggestion for that last caller?
Yeah, actually, I do carpet cleaning for a nationwide cleaning contractor. And I think if he said the carpet company was willing to come back and do the work again, if they're willing to do that free of charge, I would encourage him to go ahead and do that, but I would make sure that they put down a floor fan of some sort because I didn't really get to hear whether or not they had put any fan on it to allow it to dry.
Gotcha.
But
okay. Hopefully he's still listening.
Usually in those situations, you would put a fan, like a floor fan on that floor, and it would dry it off. And so what he's experiencing is mildew. It's not anything from a water source from a different cleanup or anything like that. It's a mildew smell that he's experiencing.
Okay. Well, thank you very much for the expertise, and hopefully he's still listening and he'll know what to do now.
Right. And I also had a question of my own.
Okay.
I got kind of like a little busybody neighbor in our neighborhood.
Yeah.
We live in a historical neighborhood in one of the boroughs, and she kind of goes around and makes sure that everybody's house, frontage is clean and all of that, and I don't mind that, but one day we came out and we caught her painting our windowsill. And when we asked her about it, she said it was because the air conditioner from the third floor was dripping down onto the windowsill and had left some rust, and she apparently, wanted to get that cleaned up. It was unsightly to her. But my question is whether or not she really doesn't have the right to come up and paint our windowsill. No, she doesn't. But why don't you ask her to build you a deck? Right.
It's a little bizarre, and she doesn't have the right to do it. And I guess, what do you do? I don't know what to tell you about one like that. I guess technically you can exclude her. I guess on the other side, you just sort of turn a blind eye to it and go, well, if she wants to do minor...
Right, yeah, and that's kind of the thing. But some things like that kind of happen often with her, and her husband is on the historical board for the borough, and I just, I wonder if maybe she's kind of overstepping those relations by going to people, adjusting people's frontages and things like that to that extent.
Yeah, I would certainly think she's overstepping. But listen, you're not supposed to stand 2 inches away from somebody you don't know, right? And you're not supposed to go in your neighbor's yard and weed their garden without talking to them first. I mean, they're just kind of social norms, so to speak.
It was one of those things where at the time, it's fine, but like if something else like that were to happen, I just didn't know what, where I would go with that.
And I'm not certain. I mean, if she's intrusive, then it's a trespass, and you exclude her.
Yeah.
Of course, it looks like there's a political overlay to the whole situation as well.
Right, and that was kind of my thing. I was like, I wasn't sure if I needed to, go to the board with that and say, hey, look, I don't mind her making suggestions, but, like making those adjustments to the property, without our permission.
Right. Yeah, I mean, the short answer is she's certainly not privileged to do it. The long answer is as long as it's innocuous, who cares?
Right. All right. Well, thanks for taking my call, Carl.
Well, no problem, brother. Thank you for the help on the other one.
Hey, no problem.
All right, bye. 540-0580. Bill.
Hey, Carl. This is Tall Bill. Thanks for your program for all of humanity. I've got one comment and one question.
Okay.
The comment is, the other day somebody called you and asked a question, and you didn't know the answer, so then you referred them to somebody else, and then you kind of laughed, and you said, you called me, and I'm telling you to call somebody else. And that reminded me, when I was in the Pentagon, we used to say, an action transferred is an action completed. That's a little joke we had among ourselves. My question for you is, I hear about short sales. What is a short sale in real estate?
A short sale is when we sell a property for less than what is owed on it. And so there's not enough money being paid to satisfy the mortgage and the cost of the closing.
Great. Thanks a lot.
All right, brother. Take care, and thank you for the compliment. 540-0580. John, you're on the air.
Hi, Carl. Hey, I really like the 2-hour format, and I enjoy your show. I just really don't want to be calling you. But here I am. Back when the water was high, during the flood, we lived by the creek. And it was over the weekend. It had gone down and really calmed down.
Mm-hmm.
And my son asked me for permission to do some kayaking, which I allowed him. I've been around water a lot, and I thought it was safe. He's 15.
Right.
Well, they fished him out down at the other end, and they called me, and I went and picked him up, and they asked me if I had given him permission, and I said I did. And so I got the citation, and it's in his name. Now, he's considering a military academy.
Mm-hmm.
He's been a good kid. He's kept his nose clean. I'm just wondering, since he is a minor and he had my permission, if I pleaded not guilty and I went in for the trial, if I would have any chance at all.
What would they charge him with?
It says flood proclamation. You're not supposed to, I guess, under a flood proclamation, you're not supposed to have any kind of craft in the water.
Gotcha.
Except for, official.
Usually what I would tell you in a case like this is, and what I would do is I go down to see the district justice and the citing people and try to resolve it in a way that results in a non-conviction.
Right.
So it's not on his record as a conviction. I mean, that's the easiest way to do it. And I mean, here's the dealio. I mean, all right, so he technically screwed up, but he did it with your permission. I mean, why are they citing him,
Yeah, that's
He's a
my
kid.
question.
So my impression on that one would be, hey, judge, officer, whoever, let's do this. Why don't we put the citation in Dad's name, and he agrees to plead guilty because it's a summary, and who cares?
Right.
In the meantime, we drop it off to kid's name, and that way it doesn't sit on his record, and everybody lives happily ever after. You guys still got your $12 in costs and your $25 fine and your $75 other dollars in administrative fees.
Yeah, it adds up.
I think that would be the best way to do it.
Okay. Well, again, I appreciate your show.
All right. Hey, thank you.
All right. Thanks, Carl.
Bye. Sounds like fun kayaking in the High Creek. I guess that's the best time to go. Bob, you're on WHP 580 with Carl Rominger. What's going on?
Is this Carl?
Bob.
Hello? Yes. like your previous caller, I enjoy your show, and I wish I hadn't called it. 20 years ago, we bought a piece of property, and another neighbor did, that shares a common right-of-way for the first 250 feet off the paved road and 50 feet wide. And there was a shared maintenance agreement between that owner and the two people that purchased the lot. We put in our driveway, of course, and added, on that right-of-way, and it's on a hill, and ours is now paved, and theirs is gravel and so forth. And we've never had to pay anything for, their maintenance or for ours. And 6 or 7 years ago, he divided off and made 3 more lots down there, 2 of which the National Park Service bought, and another fellow bought the other lot. He's trying to build, and the township has put a requirement on him to have a maintenance agreement between all parties on that road before he can do construction. So his attorney drew up and sent us a proposal. And what the proposal basically says is that we'll all share in removing snow, and we will all...
joint maintenance style agreement.
Yeah. So I got basically 2 questions. One, he wants us to sign it. We're not going to sign it, and see what goes from there. But the first question is, what protects you in an agreement like that? I mean, he could have put 100 homes back there, and the township required, a 2-lane road with curb and gutters and so forth.
Well, that's the interesting question. I mean, an agreement like that, what protects you is whatever you put in the agreement. So if you're going to do a joint right-of-way agreement, or you're going to formalize something, you can certainly say, these are the provisions I also want in here. And I want it either kept up to certain specifications, or I never want it improved past a certain point, or I don't want it for use of commercial vehicles, or, So there's a lot you could do in terms of how you author one of those agreements.
Yeah, but that was never done. I mean, basically, my question is, we had an agreement. 3 lot owners had an agreement. Now there's 6 lot owners.
Right.
He added 3. He added 4 of them later.
Well, see, now the right-of-way belongs to whatever
right.
land it was for the benefit of.
Right.
And then it sounds like one of those lots may have got subdivided again.
Yes.
And so, of course, it's still for the benefit of what we call the subservient estates versus the dominant estate. So the original tract gets divided into 3. Those 3 pieces still own the ability across that right-of-way, because that was
right.
it belonged to them when they were 1 as well.
Now, he's also added 3 or 4 more, so they also have that right.
Yeah.
Okay, but in terms of us on the original agreement, are we obligated to go beyond that, and the new 4 lot owners, we have to share in their cost of whatever it takes to maintain maintenance on that driveway?
Repeat that.
We originally had 3 people had an
okay.
agreement. Now 7 people have an agreement.
Right.
So that's added to our cost if they want us to share in their maintenance.
Potentially, yes, although there's more people to spread it across, right?
Okay. All right. Yes.
I mean, theoretically, but you're right, and these are the problems. So the other question would be, when this other fellow wants to keep expanding, and if you want to keep entering into agreements, it might behoove you at some point to say, okay, we'll enter into a new agreement, but the new agreement's got to, give a little bit and say we're not going to continue to expand our cost, or it's going to be capped, or I can't exactly tell you what to say, or maybe sometimes we have agreements that say you're only responsible for the area that passes through your own land.
Yes, that's correct. It's only the 250 feet that we're talking about. Okay. If he would have signed, if the landowner would sign that would be fine. It would be done. But the question now is the township won't let him build unless we sign this agreement.
Right. So you're holding them by the we have a term for that.
Right. Now, if we don't sign it, I'm assuming his recourse is that he could take us to court. But I don't see how you can force someone to pay potential future costs when you don't even know what they are,
he may have difficulty in court. I mean, I couldn't tell you exactly whether he would prevail or not based on what I know, but my inclination is he would have problems in court, and it would be expensive and time-consuming and take a long time. Right. So even if he did prevail, so he really probably does want your signature. So, of course, the next question is, hey, buddy, if you keep doing this, why don't you give us some green?
Right. Okay. What's your office phone number in case we go that direction?
241-6070. 241-6070. That's the office phone number, 717 area code. And that rings into Carlisle, but you can get in touch with anybody in our Lancaster, Carlisle, Chambersburg, Harrisburg, whichever the office is.
Okay.
All right.
Thank you.
Thank you. 540-0580. See you after the break. Hey, welcome back. 540-0580, answering your legal questions here live on the air. Of course, we'll be on through till 3 o'clock, so keep calling. And Larry, you're next. Hey, Larry.
Hi.
What's going on, brother?
Okay, the question I've got is, does child support fall under the same scrutiny as IRS dependency qualifications? In other words, how can you shield a spouse's income from child support?
A spouse's income. Well, let me ask it this way: if I have a kid with you, Larry, okay, and I'm paying you support, whether or not what my spouse makes is irrelevant, unless I owe a duty of support to a child with that spouse. And then we'll run those numbers only to see if there should be a pro rata reduction in what I have to pay you.
Okay, so, well, the child support would be with a former wife.
So I'm not sure I'm not following. When you say a spouse's income, so you're going to get married to a new lady, right?
Yes, that's the spouse's income that I'm trying to shield.
We don't consider that in child support. We don't consider the spouse's income for purposes of what you have to pay the other person. It can only reduce what you have to pay the other person, never increase it.
Okay, well, so if she starts a business,
her income doesn't count for you.
So the business being solely in her name is all that she needs to protect it.
Well, now wait a minute. I know where we're going now. Now you start to sound like the client I had one time who, wife suddenly started a business that looked a lot like what he was doing before he got married to the new gal. And, of course, the judge said, sham, sham, sham.
No, the income is...
What I mean by that is if the spouse creates a new business, okay, or their own business, or has their own income, we don't count it. If we think that somehow we're running the payor's income or portion of their income through the spouse's business, then it's fair game.
It's not, because he just got standard employment.
Well, that's what I mean. As long as he's got his own employment, he's doing his own thing. That's what I'm saying. So then it's not a sham.
Okay.
The case I'm thinking of, let me give you an example. Let's say I'm a roofer, right?
Yeah.
And then I marry a new girl, and I'm tired of paying for those stupid kids. So what I do is I put my new wife up in business as a roofer, and then she just hires me for $6 an hour to go up and roof while she makes $47 an hour net profit on me, right?
Yeah.
The judge would look at that, scratch his head, and go, Rominger, I think that this woman's not really a roofer. I think you're really the roofer, and you just created this structure. But judge, look, the IRS is fine with it, and so is the Department of Labor and everybody else, and unemployment compensation. And judge is going to go, that's fine, but I'm imputing you that income.
Uh-huh.
So point is, in the child support arena, what you do technically on paper doesn't control, but as long as it's legit handshake transactions and the spouse has a job or a business and does it on their own, and it's not a way to circumvent, and the burden's going to be on the other side to prove it, you don't have to defend that, you should be fine.
Yeah.
That answer your question?
Pretty well. I think she can go into business without worrying about having to.
Her income has nothing to do with her spouse's income for child support purposes, except to reduce it potentially. Okay.
Yeah.
However, and all I'm telling you is if someday we find out that the business that the spouse created is somehow really for the benefit of the other spouse somehow in a way that looks like it was designed to lower the child support obligation or to dodge a child support obligation, then it's a different story.
Yeah. Yeah. Okay.
All right, brother.
Thank you very much.
All right. Yeah. Everybody's always looking for an angle. I don't think he was, though. I think it's a legitimate question. Melody, you're on the air.
Hi. Thank you so much for your show. It's very educational, and I try to listen every week.
Well, thank you.
And I have a question about the priority on a judgment that I have filed.
Okay.
My husband and I had a tenant that the married couple that we had a judgment against, and I filed it in the courthouse. Subsequent to that, they bought a house, which is now up for sheriff's sale. And evidently they're trying to refi the loan, and we got a call from the settlement company saying that they found our judgment and that in order to clear the title, past clear title, I guess, when they pay it off, that they have to pay us off.
Right.
That was a week ago Friday. The sheriff's sale was Wednesday, and it was continued, and we haven't heard anything more from them.
Well, the mortgage company has a superior lien in the property because a mortgage perfects a lien interest in the real estate and the land.
Okay, even if we were ahead of them?
Well, you're not a how do we want to say it? You're not secured against the property. In other words, the mortgage secures that debt against the property itself.
Okay.
And I'm assuming, how did you get ahead of the mortgage? Somebody wrote him a mortgage while you had a judgment against them?
I had a judgment already against them. I was surprised they could buy a place without paying us off.
Okay, because that's the next question is could that somehow bump you up in priority? I'm just thinking out loud here.
Yeah.
Let's just think this through because it's an interesting question. So I go ahead and transfer you real estate at a time that I know. Interesting. I don't know. Maybe that does bump you up in priority. I don't know the answer to that. I can see an argument how it does because the other Yahoo went ahead and secured the property, knew that this judgment was out there.
Yeah.
Or at least had actual, constructive knowledge because they could have found it at the courthouse.
If they did the title work properly.
Yeah, so now I'm wondering who did the title insurance. Interesting. The lender may have recourse. Well, the short answer is how much of a judgment are we talking about?
$1,400.
$1,400. Yeah, I don't want to spend too much fighting that out either, though. That's the downside to that. Well, is the lender willing to pay you off as part of the closing?
We haven't heard any more. I am only assuming that this put a clink in the armor.
Yeah.
And that they haven't been able to settle the loan now. They asked me how much was I willing to how much is I willing to settle the judgment for, and I told them $1,400.
Right. Well, I'll tell you, this would be my thumbnail sketch would be if they came back to you, I'd say some amount. If you break a little bit on it, it'd be worth your while because you're going to end up spending more money to collect it if you have to fight it out with somebody later.
Okay. If it gets sold at sheriff's sale and they don't refi, and the bank buys it, does the bank have to pay us? Well, that's the interesting question. They may take it subject to that lien, and I don't know the answer. You got me thinking on this one because I'm trying to figure out. Listen, my instinct is somehow you do have something going on here because that's why we're such nervous Nellies about not writing title insurance. And it seems to me again, I just have to sit down and map this out. But it seems to me you are in line ahead of everybody else. And the bank may be stuck if they take back the asset, that your judgment may still cling to that asset. Or at least potentially. Because yours is against the person. You're not technically attached to the asset. Right. I knew that, but I thought that...
And you haven't executed your judgment against them?
What do you mean by execute?
You didn't have the sheriff go out and try to sheriff's sale their property or anything?
No.
So, and I don't know how that overlay plays in here now either because somebody else got the jump on you there. My thought on the matter would be to get together with the bank, and if they're willing to give you, 80% of what you're owed or something like that, or even, I'm not going to tell you how low to go, but I would tell you versus your cost of collection, because there's other things you're going to have to do to try to straighten this out. And the thing is, other people may not be responsible for any additional legal or procedural costs you incur.
Okay. Now,
if it was a $14,000 judgment, I'd tell you, let's sue them right now and let's just get our fingers in the pie. For $1,400, it's not clear that getting legal assistance is in your best interest at this point.
Yeah, it's a lot to me, but in the grand scheme of things, it isn't.
Right. The other thing, and I know we've done this before, and I know other law offices will do it, is you bring me the $1,400 judgment, and I'll split whatever I can get on it with you. But the short answer on that one is, then you're not getting $1,400.
Yeah.
You're getting $700 if everything goes right. But then again, your costs are fixed, and you don't have to worry about getting $12 and a $1,200 legal bill.
Okay.
So just some thoughts.
Okay.
So I don't know if you're in priority or not. That might be one we need to figure out. So Steve Snyder in my office might know the answer to that as well.
Okay.
All right.
Is there a way to check in the courthouse for priority or not?
No. There's no list of priority in the courthouse. They are when they were. They were filed when they were, and transactions happen when they were. The law has to sort it out. So I'm sure with a little research we could figure it out.
Okay.
All right.
All right. Thanks a lot, Carl. Appreciate it.
Bye.
All right.
And I'm sure some of that's going to be contingent on how a few other things play out. I don't think whether she's got a priority lien or not is always going to be clear, but it certainly creates a cloud on the title. Mike, you're on WHP 580.
All right, thanks for taking my call.
No problem.
Hopefully this is a simple question. I got a little bit careless over the summer, let insurance lapse on a car that I had in storage, and got my notice from God that they're asking for me to send in my plates for the 3-month suspension of the vehicle registration. And it looks like I don't have any grounds to appeal it or anything else. I was uninsured for about 45 days before I got it back up and got the car out of storage. But what I've seen some conflicting information on is my ability to transfer the title on this car.
Yeah.
And I'm wondering if I can get away with transferring the title to my wife. We're both on the same insurance policy. And then continuing to drive the car because I'd still be insured on it. My license isn't suspended. It's just the car registration.
Well, it seems to me that was one of the quirks of these suspended registrations is that a new title holder can get a new registration.
Mm-hmm.
And therefore, there doesn't seem to be any requirement that the new person have a relationship with you or no relationship with you. And there doesn't seem to be any requirement whether they're allowed to let you drive the car or not drive the car. It seems to be one of these quirks in the law where they created a registration suspension regime that's easily sidestepped by what you were talking about.
Mm-hmm. I did see something on the PennDOT site, and it wasn't real specific in terms of how close they look or anything, but on their FAQ page, it had the question of what if I sell the car to a family member, and it says if it looks like you're transferring the car just to avoid the suspension, then the suspension can follow the vehicle, but I don't have any idea if PennDOT actually researches or pays attention or goes after that. And
yeah, and in my estimation, I'm just trying to think. I think I've seen the situation before, and I don't ever recall PennDOT following it. But you got to do what you got to do, and I'm not sure that it's illegal for you to do that.
Okay.
In other words, I don't think there's any direct prohibition on it. And like I said, I think it's one of those quirks where, and maybe PennDOT over the last couple of years has started to catch on to that. Maybe that's why it's in their FAQ now.
Okay. And short of that, my only other recourse would be to actually take my car into a dealership, actually sell it, and get a different car, because otherwise I just can't get to work for the next 3 months, right?
Right. Well, and that's the other one that's bizarre, too, is you just sell that car and you get a new car, and I guess the state's happy because they get the sales tax.
Yeah. All right. Well, I guess that's what I'm going to try, and hopefully they won't track it too close, and if they do, then I guess we'll sell it, unfortunately.
All right, brother. I got to go to break.
Right. Thanks a lot.
All right, bye. Hey, welcome back. 540-0580, taking your legal questions here on the phone. Lorraine.
Yes.
What's going on?
I have a question for you. My son applied for a job and was not hired was red flagged.
Okay.
And he has no clue why. And he doesn't have anything on his record. He's a good worker. He's like 30 years old, you know. And there was a number to call, but he can't get a hold of anyone or find out why that happened. Now, would he need to like hire an attorney and then get that found out why he would have been red flagged, because he has no idea why?
So he tried to get a job somewhere, and they just said no?
Put in an application, right. And then he knew somebody that worked there, and they were going to get him in, you know. And the guy said, well, your application was red flagged. And he doesn't know what that entails, you know.
Well, it's hard to say why an employer would do that. I mean, this depends. No criminal record?
No.
Let's see. Well, just trying to think somebody says red flagged. I mean, was it red flagged for whatever reason? I don't know. So the short answer is I don't know how he'd figure that out. The employer doesn't have to tell us why they didn't hire him.
Yeah. But, I mean, if there's something that is on his record that isn't his, you know how it could have got put on was another person with the same last name or something like that, and if he applies for another job, it'll happen, you know, if there's something there.
Yeah, and what we would usually do in a case like that is do a state police background check.
Uh-huh.
And see what we find.
Mm-hmm. So what, would he call your office and ask you to do one of those?
Yeah, yeah. We just bring him in and help him through that and analyze it, and then also maybe a couple other things we could look at as well.
Okay.
All right.
All right. Thanks a lot.
Thanks. Bye. Yeah, you know, when somebody says a red flag, I mean, who knows why? I red flag. You know, I don't know. What do you red flag? Nothing, Shane? Yeah, I mean, I think that's the issue, and so it's hard to say what that really means. And maybe somebody just told him that because they wanted to hire, you know, maybe the other guy at work just told him that because they actually hired somebody else's son-in-law. I don't know. Mark, you're on WHP 580.
Sir, thanks for having me on.
No problem. What's going on?
Hey, question for you. I'll give you a long story short. Basically, I work for a company, you know, gave my resignation or whatnot, and while I was there, one of my bosses, you know, always had a negative tilt and everything like that, to everything, you know, blaming everyone for, you know, negativity and all this. But nevertheless, since I've left, he has been still, you know, bad-mouthing me personally. I mean, I left on my own will, bad-mouthing me personally, and I'm just concerned about my future, you know, what stories he's telling to the customers that utilize that company, you know, how that could affect me in the future. You know, it's his word, and I have no other word about it. And, you know, he's considered a reliable source because of his position he holds. But, you know, when you get down to the root of it, you know, if someone could really look into it, you would see that, you know, this is not a reliable source. So my question is, you know, how is defamation of character or a slander suit? I mean, what steps could someone take, like myself, to, you know, let's cease the conversation, let's quit bad-mouthing someone for something that was never happened or things that, you know, have been said about myself?
Right. Well, you could send a letter, I mean, to the person basically saying cease and desist.
Sure.
That's usually the beginning, and then if they are defaming you, I mean, it actually is defamation, you ultimately can file a defamation lawsuit and say, hey,
Sure.
You're defaming me, you're slandering me, and if you win, you'll get money damages, and if they persist, you know, you can probably get punitive damages at some point.
Sure. Okay. Now, do I need to contact an attorney, like your office, to have that letter written?
Well, you mean you could write your own letter, but I sort of have this theory that when something comes on attorney letterhead that says, hey, stop this, it tells the other side, well, he's already lawyered up, so maybe he is actually serious.
Sure, absolutely. So, okay, so the first step would just be, you know, contacting an attorney. Hey, can you write a letter for me? You know,
right.
Paying whatever that cost is.
Right, and so, it's probably not prohibitively expensive just to write a letter. And if the other side doesn't cease and desist, the other thing you have going forward is that they were put on notice that they were saying things that were untrue, and
sure.
And therefore, if you can think about it, it becomes more willful and wanton, and therefore
sure.
more likely to be punishable
Sure. I mean, because I was at the company for quite a few years, and it's one of those things you build relationships, and those people who are your allies are coming back. Hey, it's just it's your old job, and
right.
One of the managers is saying, oh, you did X, Y, and Z, and that you were fired from here, and never give you a good recommendation. It's like, well, I left on my own terms. You know what I mean?
Right. All right. Well, that's my advice.
Okay, I appreciate it, sir. Have a great day.
All right, brother. 540-0580. And, of course, remember, we're going to continue into the next hour here. Ken, what's going on?
How are we doing today?
Good.
Good. Quick question for you. I have a friend who has some investment properties,
mm-hmm.
and he received a call from the law enforcement and asked if a certain one of his residents had paid his rent recently with cash, and he had. And the police department come out and they wanted to see the cash.
Huh.
So he paid with denominations of 20s to 100s.
Right.
And they have a sheet with all these different $20 bills on it, and they're looking and they're pulling these $20 bills out, and they tell my friend that they were involved in a drug deal.
Right.
But they take all of the money, not just the 20s. They take it all, and they're telling him he can't get it back. Does he have any recourse?
Well, yeah, I mean, it's his money. It was paid to him for rent. I'm not certain that the police can impound the money at that point. What they're trying to do, though, is they had photocopied the serial numbers on the bills they used in a drug transaction, and they want to prove eventually that this money flowed from the drug transaction to the drug dealer, and to show the drug dealer possessed it, he paid it to his landlord. It seems to me, and I don't know how much money we're talking about, but it seems to me this would be one where we could probably make an agreement with the police, which is once this guy pleads guilty or is found guilty, return the rent money.
Well, he asked already about getting it back, and they told him that he wouldn't get it back.
Well, listen to me. Listen to me. When the police arrest you, they tell you you're going to jail, too, but when you hire a lawyer, it doesn't always happen.
It was actually $1,000.
Yeah.
And
well, he needs to come see. He needs to come see me. We'll get his money back.
Okay.
All right.
I'll tell him that.
540-0580. Hang on, Bruce. Hang on, Steve. We'll be back after the break.